Good morning. My name is Maurice Crespi. I'm managing partner of Schindler's Attorneys. Schindler's Attorneys are a co-founder of COBRA. COBRA is South Africa's biggest, largest pro bono initiative to assist companies in distress. We're doing so various means, by providing advice, by having private Zoom sessions, by having our turnaround experts assist in having your business recover. Importantly, what COBRA does is we negotiate on your behalf with your creditors by inviting them into the COBRA ecosystem and having us deal with their creditors. So the idea is we go all the way up the supply chain and negotiate arrangements, cash flow arrangements, which work for each debtor and each creditor, all the way up to the bank. So the idea is to ascertain each business's needs, interests, and concerns, and to marry those up. And that is all done on a pro bono basis. So what we also do are sessions and webinars such as today. I'm just going to mute one of the panelists who's just joined. There we go. And today's webinar is exactly that. So on Mondays and Tuesdays, we have general webinars in relation to business rescue. We give you a rundown of the process, the legalities, and what to look out for. Then on Wednesdays, Thursdays, and Fridays, we have one or more targeted webinars where we deal with specific topics. Today, we'll be dealing with labor law and retrenchments specifically. I'm joined by a whole host of panelists from the various COBRA partners. I'm joined by Pierre van der Merwe. He is my partner. He heads up our labor department at Schindler's Attorneys. We have Ian Fleming. He's the CEO of Engaged Turnaround. They are the turnaround specialists who jump in there and assist wherever they can. They give more specifics in relation to how they assist in the Monday and Tuesday sessions. So please join those. You can register today. Then we have Simone Simley, an attorney at Schindler's, also in the labor department. Dean Wright, he's my partner at Schindler's. He's on today. He's our expert at COBRA in relation to the various relief funds. I don't think he'll be speaking today, but please bear in mind, COBRA has what we're now told is the best and most impressive database, knowledge database in relation to the funds. And there's robotic AIs, chatbot bots, and that kind of stuff to guide you through the process. And that's another COBRA function. So, yeah, if we can assist you there, please be mindful of that. Then we have Peter Gordon. Peter is an expert business rescue practitioner. He's also part of Engaged Business Turnaround, but he's also very much involved in private equity, Crest Capital, which is another business of his, and he also provides incredibly insightful information from a market perspective, from an economic forces perspective, and from a solution-based perspective when it comes to businesses in distress. He has years and years of experience, so please watch out for him. He provides that insights in the Monday and Tuesday sessions, which are invaluable. So if you haven't seen those sessions, please, I urge you to join. We then have Alicia Naik, also from Schindler's legal department, labor department rather. Emma Marseille from the IQ Business Group, also a COBRA partner, and importantly, deal with the big companies, the employers 500 plus. That's where they plug in. So we have different specialists in different industries. We actually have specialists to deal with the spaza shop type businesses all the way up to listed entities. And that's where IQ Business, also a co-founder of COBRA, plugs in. We have Artisha. Artisha is from IQ. And we have, did I mention Dominique Lloyd, also labor at Schindler's, and Gary Barachowitz, who deals with sports and entertainment law. You'd ask why he's part of this. Well, he runs COBRA TV, and COBRA TV, the view of COBRA TV is we become a 8-hour-a-day webinar channel, so he's dealing with that. I'm going to kick off with labor law because I also do quite a bit of labor law myself, and I'm just going to give you an intro of what I deal with on the Monday, Tuesday webinars. and it's very, very, very brief. So firstly, COBRA is not about business rescue, whilst you may think it is. It's not about legislative business rescue. It's not about you signing a resolution, going into business rescue, and the whole world thinking that you in distress and you in the departure lounge. That's not the case. What COBRA is about is saving your business and avoiding a business rescue. And we tell you how we do that on the Monday, in the Monday and Tuesday sessions. But when it comes to saving the business in a rescue, the labor laws still apply. You cannot suspend an employment contract as you can, as a business rescue practitioner can. When it comes to lease agreements, you can suspend the obligations there. But what cannot happen is a suspension of an employment contract. And importantly, when it comes to varying an employment contract, what we've seen is that employers are of the view that they can come in, and because there's a cash flow crisis or cash flow constraints, they believe that they can willy-nilly just say 50% slashed off the salary bill, that's the way it is, take it or leave it. You simply can't do that. You still have to go through a process, and the process that you go through is Section 189 of the Labour Relations Act, which deals with retrenchments based on dismissals based on operational requirements, i.e. retrenchments. So one asks, why would you look to that section when it comes to not a retrenchment, but a variation in, let's say, salary? The reason you look to that section is because to vary a term, you have to give, you have to consult, and you'll hear about the consultation process from the Labour team, but you have to reach agreement on a variation. So if you want to reduce your staff salary by 50%, you must try and reach agreement on that. If you cannot reach agreement, then you have to offer a retrenchment as an alternative to the variation. And that's why, because of that offer and because of the requirement that you've got to put that on the table, that's why Section 189 applies. So take home from today, I've dealt with it very briefly. We will deal with that in more detail in the other sessions, the Monday, Tuesday sessions. What I don't deal with in the Monday, Tuesday sessions in detail is the retrenchment process itself. So the SAA type scenario, there's been a recent judgment in relation to the publication of the Business Rescue Plan and the timing of the retrenchment process. Retrenchments now are becoming a reality as opposed to just variation of employment contracts. So I'm going to hand over to the Labour team. They're going to start taking us through the legal landscape. I think I'll be starting with, is it Pierre? Am I right, Pierre?
Yep, that's it.
Will you be kicking
Thanks,
off?
Mac.
Will you be kicking off today?
Great, yes, thanks for that, and good morning to all the attendees. Yeah, I think that's a brilliant introduction. It's sort of hit a whole bunch of important points, but maybe before we go into actually what retrenchments are and how they can be done, let's maybe take a step back first and say, how are employment contracts ordinarily terminated, right? So the Labour Relations Act makes provision for three, or let's say four main ways in which an employment agreement may be terminated fairly or lawfully in terms of the LRA. The first way is sort of your most common, and that's usually arising from misconduct. Okay, so it's something that the employee has done that likely would have caused some breakdown in the trust relationship, and as a result of that, it's categorized as a misconduct, and the employer is then able to commence a disciplinary process as a result of that conduct. So importantly, that's as a result of the employee's conduct. Your other category is dismissals that arise due to incapacity. So incapacity is poor performance or ill health by a particular employee. Again, incapacity's got its own set of requirements that must be followed. But importantly, it is as a result of something that the employee has done. It is something, it is poor performance, it is ill health by the employee, it's injury or sickness by the employee. So misconduct and incapacity relate to conduct that is the conduct by the employee that causes the relationship to terminate, the employment relationship to terminate. Now you've got your last sort of category, or your third category. One other category that you have in order to terminate the employment relationship is by employee's conduct in resigning. Okay, so there you've got your three types of ways which an employee, or as a result of employee's conduct, the employment relationship can come to an end. Your fourth one, and the one that we're going to be focusing on today, is operational requirements, also known as retrenchments or redundancies. They're all sort of used interchangeably, those phrases or words. And the fourth one, operational requirements, arises not due to the conduct of the employee. Okay, so it's not due to misconduct. It's not due to incapacity. It's due to the operational requirements from the employer side. So it is something that the employer decides. So it's something that the employer initiates. So it's irrespective of the employee's conduct or incapacity. So I think just to put what we're discussing today into context, those are the four ways in which an employment relationship can be terminated, and we're going to be focusing on one of those, and that today is operational requirements. And obviously it fits in perfectly, or it is exactly what COBRA is all about, because it's businesses that are in financial distress. So Maurice mentioned something very important, and he said, when you want to unilaterally vary terms and conditions of employment, you need to consult, and you need to agree with the employees about that unilateral variation. Now, the key aspect of a dismissal based on operational requirements is also that golden word, consultation. Okay, an employer must consult with the employees as soon as a dismissal based on operational requirements may arise, or as soon as the employer contemplates that there could be a dismissal arising from operational requirements. Now, the purpose of the consultation, consultation is maybe, sort of a fancy word, where it's actually just a discussion, right? You're having a discussion between the employer and the employee. And the purpose of the discussion is to share information both ways. So that discussion is one of the most important. It's the most important thing that you should be doing through a consultation, and it allows the free flow of information from both sides. Importantly, the decision to dismiss must never be taken before you've started consulting, okay? Because then the dismissal is a foregone conclusion. So an employer shouldn't wait until it's too late to start consulting. Employers should consult as soon as retrenchments are contemplated, as soon as there's the thought or the possibility. And then it is important that the employer starts consulting, so that you don't have a situation where it's too late and the consultation process is futile because the decision's already been made. The circumstances already arise that the dismissals must happen. So again, Maurice hit the nail on the head. The most important section is section 1893, or section 189 of the Labour Relations Act and 189 capital A of the Labour Relations Act. I'm going to ask my colleague Simone to just take me through, to just take us through what are the legislative requirements that arise or that are stipulated in terms of section 189. So let's look at the framework that actually arises from the legislation. Hi, Simone, can you take us through it?
Good morning, everybody. So Section 189A deals with large-scale retrenchments. So this is where the retrenchment will be for 50 or more employees. For the purpose of today's webinar, however, we'll be dealing with Section 189, which is small-scale retrenchments. But should any of the attendees have any questions, please direct them to us and we will gladly assist. So let me have a look here and take us through the Act. Section 189. When an employer contemplates dismissing one or more employees for reasons based on the employer's operational requirements, the employer must consult any person who the employer is required to consult in terms of a collective agreement. If there is no collective agreement that requires consultation, a workplace forum, if the employee is likely to be affected by the proposed dismissals, are employed in a workplace in respect of which there is a workplace forum, and any registered trade union whose members are likely to be affected by the proposed dismissals. If there is no workplace forum in the workplace in which the employee is likely to be affected by the proposed dismissals are employed, any registered trade union whose members are likely to be affected by the proposed dismissals. Or if there is no such trade union, the employee is likely to be affected by the proposed dismissals or their representatives nominated for that purpose. Subsection 2 says that the employer and the other consulting parties in the consultation envisaged by subsection 1 and 3 engage in a meaningful joint consensus-seeking process and attempt to reach consensus. So this is what Pierre was referring to. It has to be an open flow of communication, and they are basically collectively trying to reach some sort of agreement. Now, what are the agreements reached on? Appropriate measures to avoid dismissals, to minimize the number of dismissals, to change the timing of the dismissals, to mitigate the adverse effects of the dismissals, the method of selection of the employees to be dismissed, and severance pay for the dismissed employees. The employer must issue a written notice inviting the other consulting party to consult with and disclose in writing all relevant information. So this is subsection 3, which is essentially the most important, as discussed by Maurice and Pierre. And let's go through here. Number 1, the reason for the proposed dismissals. Number 2, the alternatives that the employer considered before proposing the dismissals and the reasons for rejecting each of these alternatives. Number 3, the number of employees likely to be affected and the job categories in which they are employed. Number 4, the proposed method of selection of the employees to be dismissed. 5, the time when or period during which the dismissals are likely to take effect. Severance pay proposed. Then any assistance that the employer proposes to offer the employees likely to be dismissed. The possibility of future re-employment of the employees who are dismissed. The number of employees employed by the employer. And lastly, the number of employees that the employer has dismissed based on operational requirements in the preceding 12 months. So this, as we have said, is obviously the most important part. My colleagues will deal with certain aspects of these sort of requirements that are more legally complex, as a number of them are quite self-explanatory. But let's have a look at the rest of this section. So subsection 4, the provisions of section 16 apply, read with changes required by the context to the disclosure of information in terms of subsection 3. If any dispute in which an arbitrator or the labour court is required to decide whether or not any information is relevant, the onus is on the employer to prove that any information that it has refused to disclose is not relevant for the purposes for which it was sought. The employer must allow the other consulting parties an opportunity during the consultation to make representations about any matter dealt with in subsection 2, 3, and 4, as well as any other matter relating to the proposed dismissals. The employer must consider and respond to the representations made by the other consulting parties, and if the employer does not agree with them, the employer must state the reasons for disagreeing. If any, okay, Gary's just asked me to share my screen here. Give me one moment. Okay, to not waste any time, I'll just take us through the last bit and then I'll see if I can figure this out. So the employer must select the employees to be dismissed according to a selection criteria that has been agreed by the consulting parties, or if no criteria has been agreed, a criteria that is fair and objective. Okay, so I think Alicia is going to be dealing with the reasons for the proposed dismissals. So I'll now hand over to Alicia.
Okay,
Thank you, Simone.
Thanks, Simone, and thanks, Alicia. Okay, let me also just quickly hop in there. So we've now looked at the legislative framework that is applicable whenever there is a retrenchment, whenever you want to dismiss based on operational requirements. We're going to, and as Simone said, section 1893 is the most important section that you have to look at. It's got, because it lists all those important factors that need to be consulted on. We're not going to deal with each of those factors because some of those factors are self-explanatory. You know, listing the number of employees that is employed by the employer. But we do want to quickly touch on some of those that are important, or that are a bit more legally complex, and where we also find we receive lots of questions. So maybe if Alicia can just take us through one of those factors in that section, or in 1893, and that's obviously a very important section, and that is what are the reasons for the proposed dismissal?
Right. Thank you, Pierre. Good morning, everyone. So as Pierre correctly mentioned, this is one of the first elements that you have to consider in the consultative process, whereby an employer must give a complete breakdown of all the reasons that they've considered as to why they wish to embark on the retrenchment process. So some of these are explicitly outlined in section 213 of the Labour Relations Act and include economic reasons, technological reasons, and structural reasons. There also could be other reasons, such as the need for specified qualifications, a specific niche skill set that may render certain people redundant based on their qualifications. Technological reasons, we see this a lot in large-scale factory workers where new equipment and technology is advancing at such a pace where there isn't necessarily a need for such a large labor force. In the financial services industry as well, we see new advancements in computer technologies all the time, new software that renders certain roles redundant. Structural reasons, where businesses may wish to move from functional corporate structures to more project-based structures, where perhaps a rejigging of your organogram could result in certain roles becoming redundant. And today, obviously, the most relevant one in light of COVID-19 would be economical reasons, where businesses can no longer afford their operational costs due to the economic downturn of the economy as a result of COVID-19. So we'll see that it could result in immediate cash flow shortfalls, where businesses don't necessarily have the funds on hand currently or within their projected future income statements to continue their operations. So these are some of the reasons that can be contemplated as to why an employer should embark on the retrenchment process. And I think Pierre will take us then through the next as to alternatives that could be considered as opposed to retrenching.
I just jump in there.
Yes, Mac.
I just want to just jump in and just have a point out and see whether you agree with me on this point. So ordinarily one has to consult on, as an example, the reasons for the proposed dismissals, okay? And what I've been suggesting, and I want to see if you agree with me, is that when it comes to dismissals based on operational requirements, it's usually quite a lengthy process. But now, because the reasons are so obvious and the factors are so obvious, the process, in fact, can be abridged in comparative to how it's been. I mean, one does not need to spend hours and hours and hours poring over cash flow statements to actually see whether there is indeed a reason for the proposed retrenchments. We just know because of an act of God. Would you agree with me that the labour courts are going to be pretty lenient when it comes to the time periods? You know, they've always said it's got to be meaningful. You must take your time. But I think we're in very different territory. Your views, Pierre?
100%, 100%. So, I mean, what are the requirements of a fair dismissal? You've got to have a substantively fair reason, and you have to have followed a substantively fair process. So, given the pandemic, given where everyone is, the global economy, the local South African economy, there's chances are there's already a very good reason. I suggest
no chances are. The reason's there. It's presented.
Yeah.
So that you basically can spend 30 seconds on that reason, whereas that could have taken days, you know, in a normal process. Whereas now you're not faced with a scenario where one actually has to do a deep dive into the facts. The facts are just there.
Yeah.
So interrupted. Carry on with your presentation.
So that's exactly it. You could do that, and I think that's going to be much shorter. And I think also just on the time periods point that you mentioned, Section 189 doesn't make provision for any time periods. So there are no time periods. It's only Section 189A for large-scale retrenchments that time periods become applicable. But there are no prescribed time periods for a small-scale retrenchment.
Yeah, there are no statutory time periods, but the court will assess the reasonableness of whether the consultative process was meaningful, regard being had to the amount of time afforded to the employees to consult on the issues.
100%. 100%. Okay, so let's then just, if we move on, I think there's one or two more things that I'd like to touch on that I think is important from a retrenchment perspective before we really open up the floor, and that is we've now dealt with the reasons for the retrenchments. There's two other aspects that I think it's worthwhile discussing now. They're listed in Section 1893, but they're tricky. So one of those aspects is the alternatives. Now, an employer is obliged to consult with an employee on the alternatives that are available prior to implementing the involuntary retrenchments. Now, there's no closed list of alternatives. The alternatives are as far and wide as creative as you want to be with them, and as long obviously as it's reasonable and you can ideally agree with the employees on those alternatives. But just by way of example, there's some alternatives could include reduced time, reduced salary. It could include a voluntary retrenchment package, for instance, as a measure to avoid involuntary retrenchments. But there really is, the sky's the limit. You could also look at, for instance, applying to TERS, UIF. That could just be, again, tied in with a reduced working time. So there are a few options that are applicable. Okay, and I think on your screen now you've got you've got the relevant section. Maurice is just sharing his screen there. So that's going to take you through. But I mean, luckily with a quick Google search, you're going to be able to see what Section 189 says and read it. It's in fairly simple language, and it sets out the process quite clearly. So
I can just jump in. Let's just quickly go through them. So we have the reasons for the proposed dismissals, and I just want to do this, contrast this now, just around the timing. Reasons for proposed dismissals, relatively quick. Alternatives, you need to spend time. Number of employees likely to be affected, that'll be quick. Well, no, everybody's generally affected. Proposed method of selecting which employees, that may take some time, because you've got to assess, obviously, the operational value to the business, salaries, cash flows, etc., etc. The time when, or the period during which the dismissal is likely to take effect, that would be relatively quick. Any assistance that the employer proposes to offer to the employee is likely to be dismissed. I think that would be relatively quick, because, I mean, it would be, obviously letters of reference and whatever. The possibility of future re-employment of the employees who are dismissed. Now, this is quite an interesting one, because when it comes to a normal, usual, outside of active guard retrenchment process, what happens is, if you act for the employer isn't really minded to re-employ. Okay, there isn't this massive desire, and it's not an agenda item. Whereas what we're finding is that it's very, very different, because hopefully the economy will find its way into V. In America, they're saying it's going to look like the Nike whoosh. It's going to be like this. But let's say it's a V. Economy goes down, retrenchments here, and then the V goes up. There's a fast, sharp recovery. And when that recovery happens, you're going to want to need the staff, because you're going to have that increased capacity. So I think that's actually quite important. And I think we're going to see a very different application to the rehiring. I think there's going to be a very good chance that retrenched employees are going to be rehired, but obviously that's industry specific. I don't think travel agents or pilots or air hostesses are going to be hired back anytime soon, and that's where COBRA looks at aspects such as reskilling and assisting along those lines. Again, I interrupted, Pierre. Please carry on.
No, Mac, well, that's maybe on that possibility of future re-employment. We get a lot of questions about an obligation to re-employ employees that have been retrenched. And maybe you can also just say if you agree with me here, but I think it's a bit of a common misconception that an employer must re-employ employees that have been retrenched. The obligation to re-employ employees that have been retrenched only arises if there was an agreement that was concluded through the consultation process to re-employ employees. If there is no such agreement, I would say that you don't need to re-employ those employees. Obviously, there could be the perception if you now go and retrench employees and 2 weeks later you re-employ other employees. So there's definitely that perception that you should dispel.
I was about to say, sorry to interrupt once again, but I was about to say that I think it's really the inferences to be drawn. So what would one infer if you dismiss employees because of a certain event based on operational requirements, and then what happens is that event, okay, disappears, so it's no longer present, and in those circumstances, other employees are hired, okay? Then it begs the question, why were the first employees not rehired? And the inference is that the employer's motive was ulterior, okay, that it wasn't actually based on the operational requirements. So that's where it becomes perilous, is when it comes to the inferences that can be drawn in relation to the employer's conduct post-retrenchments. And that's across the board. That's in relation to any factors that one can look at to draw inferences from. So I do agree with you there. There is no statutory requirement, but there's an evidentiary question mark that arises when the employer doesn't employ and employs other people.
Yes, and so it is something that employees should also consider. If you are going through a retrenchment process, try and reach agreement with the employer on the possibility of future re-employment, because the employer is not obliged to re-employ. So it is just something to consider. But okay, so Maurice and I obviously quickly taken us through that list, and him and I agree on the factors that could be an issue. And I think the one is the alternatives, which I've quickly discussed, and the other one is the method of selection, Mac. This is tricky. I mean, how do you go about selecting the employees?
Okay, I want to jump in there, because there's a great question that I answered online. Let me just find it. Where did I find it? But it was in relation to the employment of a employment of one employee in circumstances where you're dismissing another. Okay, now that's pretty, it sounds pretty alarming, but think of the scenario. If you're dismissing one employee in a department because that employee is completely redundant, under the particular circumstances, the employee doesn't have a job. So let's say there was a travel division, that travel division's gone. So you're going to be retrenching those employees. But now there are other employees that you can hire. And if you hire those employees, your income's going to go up because they're brilliant salespeople, let's say. In those circumstances, it would be justifiable to, in fact, hire whilst selecting employees to dismiss. So it's really, one has to look, and one must take a step back and look at the business purpose of what you are doing. Is there a sensible business and operational purpose to do what you're doing? And there are certain circumstances where you can be firing and hiring at the same time, and it is still fair. Would you agree with me with that, Pierre?
Yeah, definitely. I mean, ultimately it's what's happening in the business. Like I said, the operational requirements it's all because of what is happening with the employer. It's got nothing to do with the employees.
Yeah, so that's exactly it. So when it comes to operational requirements, those are the key words. What is operationally required is the inquiry. It's nothing else. It's not binary. If A, then B. So if you're hiring and firing at the same time, then it equals unfair. It doesn't work that way. So that's very, very important, that you've got to apply business judgment, business efficacy to what you're doing, because you've got to be able to justify it substantively. As Pierre told you, there's substantive fairness and procedural fairness. So substantively, you have to justify ultimately to the CCMA or court that there was a business purpose in what you're doing. I don't know if the labor team are pretty much done, but we can move over to, when you guys are done, let us know, because what I'd like to do is I'd like to ask Peter or Ian, I see Ian's also on, to take us through practically how now business rescue practitioners deal with employees in the business rescue process. So are you pretty much done, Peter? Is there anything other panelists want to add?
Yeah, the only thing that I'd like to add just on this, specifically the method of selection. So the scenario that you've presented of hiring and firing at the same time, it is possible. It's not prohibited, but the key word there is that it's justifiable. And it's got to be objectively justifiable, because you're going to have to explain. And obviously, if you're going to enter into this realm of hiring and firing at the same time, you're going to have a lot more explaining that you have to do. Although it is legally possible, you need to have your ducks in a row in order to do that. But yeah, I think we've pretty much covered the basics on that. And I'd love to hear from the actual business rescue practitioners what they do in practice. And then I think it's also maybe worthwhile, we should throw that latest SA Airlines judgment by Judge Van Niekerk that came out, I think, last week, Thursday. Yes. Let's discuss that.
I think that's an important judgment. I know Peter's been following that, and Ian has. I see Ian's put his screen on, so I assume he's going to be dealing with the process. Remember, Ian Fleming is the CEO of Engaged Business Turnaround. He is one of the COBRA co-founders. Basically what happened is myself, Ian Fleming, and Adam Kraker of IQ Business, we got together the very next day after the announcement of lockdown, and we got together and we said, okay, we have the skills, we're going to assist. So Ian Fleming is the man I spoke to the following morning, and I said, we've got to do something. He immediately agreed. So thank you, Ian. Let us know what happens on the ground.
Thank you, Maurice, and welcome to all the attendees. So 10 days after the business rescue practitioner is appointed, he's required to hold a Section 148 meeting. And at the Section 148 meeting, he lets the employees know, or the employees or the employee representatives, or the trade unions, as the case may be, who represent the employees. He lets them know whether he believes there's a reasonable prospect of the company being rescued or returned to a solvent going concern. Obviously, the possibility exists for business rescue practitioners to simply wind a company down and give creditors a better return than they would receive in a liquidation scenario. So your employees are obviously most interested in whether the company is actually going to be returned to a solvent going concern, because that's going to see their jobs being preserved. So that meeting takes place, and during that meeting, and it's typical for the business rescue practitioner to then let the employees know whether they do envisage retrenchments during the process of business rescue. Now, the SAA judgment, which I'll touch on very lightly, and the Schindler's team can probably shed some more light on it, but it was very interesting. Peter and I were actually speaking to the attorney last week who acted for NUMSA and the Cabin Crew Association in the Labour Court in getting that judgment. And the judgment stated that that it is procedurally unfair to employees for the retrenchment process to start whilst the company is in business rescue, but before the business rescue plan has actually been published. So I thought about this very briefly, and I said to the attorney, but does this not create a huge anomaly in that retrenchments can carry on as normal up to the date that business rescue starts, and then retrenchments can carry on from the date that the business rescue plan is published and approved, but in between the company going into business rescue and the plan being approved, you can't commence a retrenchment process. And he agreed. He said, that's exactly
what. Doesn't it go further? Does it not mean that you have to suspend those? So you could start a retrenchment process, and then you'd have to suspend it.
Yes.
Is that what's being said?
Well, yes, it probably does mean that. Yes, the retrenchment process.
Until the business plan. So what you're actually saying, and I'd like to hear from the team, but I haven't read the judgment, but what you're saying is that the employees will not be afforded the benefit of that period of consultation where they can throw out ideas, they can come up with ideas and stuff and consult, because that would be unfair. That sounds odd, and let me say this to you. Judge van Niekerk is an exceptional judge, so we'll provide a detailed analysis of the judgment to answer questions like that, because I have no doubt that Judge van Niekerk would have considered the ramifications and permutations of a judgment along those lines. So we'll have a look at that, but that's interesting, because it does have that effect. It sounds that it is
very interesting.
It's got
huge ramifications. And yes, I mean, we're not criticizing the judgment either. We are just stating that there's certainly a lot of business.
It's okay to criticize judges. It's okay. Judges are known to be wrong.
Sure.
So yeah, okay, the process.
Yeah. So yeah, I'll carry on with the process. So that's a very interesting one, and it's certainly going to affect business rescues going forward, because it is very normal for business rescue practitioners to start the retrenchment process before the business rescue plan is published. Especially if it's a complex business rescue plan that requires a lot of work to be done and might be delayed. The publication of the business rescue plan might be delayed for several months. And if the company's got no money, then I mean, it simply has to start the retrenchment process. So yeah, it's going to have very interesting ramifications. Typically, yes, and then so the business rescue plan would typically then spell out exactly what the retrenchment process is. What the retrenchment envisages, how many people will be retrenched, what the financial effect of the retrenchment will be. And remember, the business rescue plan includes 3-year financial projections that show how the company will perform financially in terms of income statement, balance sheet, and cash flow projections for the next 3 years, as determined by the business, or as estimated by the business rescue practitioner. It's important to note, as estimated by the business rescue practitioner at the date that the plan is published, based on what he knows about the company and based on how he sees the rescue plan unfolding. And in those 3-year projections, the effect of retrenchment will obviously be spelled out, and will most likely show how the financial effect of retrenchment, in other words, the reduction of your staff cost, and then over time, if the company is to be returned to a solvent going concern, how the staff costs will then increase again as the company's turnover increases. And that brings me to the next point, which we have been working with most companies, and which is actually probably going to create a paradigm shift in the way that business is done across the country and probably across the world. And that is what we've been saying right from the outset, even pre-lockdown, is that companies have to move to a variable cost business model. And it's inevitable that this is going to happen. When we talk about a variable cost business model, we talk about changing fixed costs, which have traditionally been salaries, rental, and so forth, to variable costs. And unfortunately, well, fortunately for some, unfortunately for others, we won't have a choice. The economy won't have a choice to move to a variable cost business model whereby your cost structures are linked directly, as directly as possible, to your turnover. In other words, you would have seen Spur Group came out a few weeks ago, and they said that should they reopen again, or when they reopen once lockdown is over, they will have no choice but to pay rentals, their landlords, a minor turnover-based rental as a start, and then over time, obviously, as turnover increases, then the rental will increase. So, and salaries are the same. The only way companies can survive, the only way to move forward is to reduce salaries quite substantially in most cases, and then link them in one way or the other to turnover. And this can be a case of simply reducing salaries. We've been doing it. We've been engaging with staff very proactively. Most of them would rather see their salaries reduced substantially than get retrenched. And then there has to be a system whereby as turnover grows again, then the salaries can be increased. We've done this in ways where we've reduced salaries by up to as much as 100%. Let's use an example of, say, 30%. We reduced the overall salary cost to 30% of what it previously was. In other words, employees take a 70% pay cut, and then as the company comes out of lockdown, starts increasing its turnover, then we incrementally increase the salaries again. Another way to do it is to be completely transparent with your employees, and we've worked on models like this as well, whereby we say to the employees, our turnover is currently zero, you are still employed, but your salary is zero, and then you obviously need to get their agreement as part of the Section 189 process to that, the consultation process, and then you let them know exactly what your turnover is. Completely transparent model. Every month you show them what the turnover is, and you pre-agreed a certain percentage of that turnover will go to salaries. So you pre-agreed with them that 40% of turnover at the end of May will go to salaries, and it will be prorated according to what each employee was earning before. So those are just some practical examples of how we're working at the moment. Back to you, Maurice.
Thanks very much. We have a question that I'm going to ask Dean to deal with. Before you answer the question, Dean, maybe just give us a brief overview of the status of the various relief funds. The question relates to, let me find it. It was Graham's question. That's an open question.
I've got it in front of me, Maurice.
Employers seem to be under the impression that employees participating in the TERS, you've got the question there.
Yeah, absolutely.
That constitutes an acknowledgement that their employment has ended. Can you talk us through that?
Sure. So morning, everyone, and morning to the attendees. I think what we should just touch on briefly while we have TERS in the spotlight is there's a wealth of information on the cobra.org.za website that I would suggest every single of the attendees this morning go have a look at. What you'll see if you scroll down to the bottom of that website, there's a knowledge base and a knowledge portal that what we've done, and you mentioned it earlier in the webinar, is that we've spent many, many hours in putting together a huge database of all the available initiatives that are currently available to at various levels, the companies, SMEs, as well as individuals in South Africa. And I know that given the topic of today's discussion, TERS is a predominantly popular initiative, and one that we ask quite a lot on. So if you go to under government initiatives on that knowledge base and you find the TERS one, it'll have a snapshot of the most important documents you need, how to apply for it, and so on and so forth. But to get back to Graham's question here, the question is, employees seem to be under the impression that employers seem to be under the impression that employees participating in TERS schemes somehow constitutes an acknowledgement that their employment has ended. And I think, Graham, the confusion comes in is that the TERS scheme is administered through UIF. And obviously the connotation is that when you start dealing with the UIF, for the audience out there, it stands for the Unemployment Insurance Fund. I assume that's where the confusion is arising. But TERS is a separate scheme. It's just administered by the UIF. And for an overview on TERS, it's a scheme that allows employers to apply for a subsidy and a percentage of the employee's salary, and it's worked out on a maximum salary of about 17,000 Rand. And there's various scales and percentage of what percentage you may claim through the TERS scheme to supplement or to, I suppose it is supplement employees' income. So the TERS scheme is specifically for people that are employed or have been their employment, or who are employed who have not been able to work as a result of COVID, or have been able to partially work as a result of COVID. So no, it's not. They're completely distinct, I think, concepts. If it wasn't an employee, you would then make the normal process through the UIF, which would be the Unemployment Insurance Fund.
Great, that's fantastic. We're almost done for the day, but I think there's a take-home that we mentioned on our Monday and Tuesday sessions. It's very important because it relates to employment. And I'm going to ask Peter to take us through the notion of post-commencement finance, where you have to be a business rescue to get the benefits of post-commencement finance. In the context of shareholders and directors, funding shortfalls in staff salaries out of their own pockets. So in other words, if there's no cash in the business and you want to pay salaries out of your own money, that is a reason to go into business rescue, even if creditors are not applying pressure. Why is that, Peter?
Maurice, thank you for that, and morning, everybody. The critical issue here is that the legislation is drafted such that it's attractive for people to invest in a company post-rescue rather than pre-rescue. If it wasn't so, it would be almost impossible to raise funding for a rescue, and if funding's not available, the rescue will not succeed. So what the issue that Maurice is referring to is a shareholder director who's been funding the business, especially in the SMME market. Very often the case that hasn't got the cash in the company, so puts further personal funding into the business. If you do that and you're not in rescue, i.e. in the ordinary course of trading, and then the company subsequently applies for rescue, then your funding is lumped in the pot with all the other debt of the company, and you can only be repaid in terms of the business rescue plan. And that, as Ian was saying earlier, might well include a compromise with creditors, such that you don't get your full money back. If you, however, put the money in after rescue, you're immediately preferred, and that means that the practitioner has to pay the preferred suppliers of funding or credit before he pays anybody else. So the creditors, as at the date of rescue, are frozen. Everybody post that date are considered preferred if they've provided funding into the company. So, and he's also allowed to issue security in favor of any funding received whilst in rescue. So if there's an unencumbered asset available to him, he can secure that to a shareholder's funding. And then the shareholder or director who's providing the funding becomes super preferred. The interesting thing vis-a-vis staff is that staff have a say in the business rescue process from the beginning to the end, because they are creditors. Firstly, they're creditors each day you haven't paid them. They've always got unpaid leave pay, etc. So they are by default creditors. Ian talked earlier how they have to be consulted in terms of the 147 meeting right at the beginning, but any court action that the practitioner decides to take on behalf of the company, the shareholder, the employees have a right to be involved in it. And then importantly, the business rescue process freezes all contracts. So there's a moratorium on all contracts other than employment contracts. It's the only exception. So we were talking about the SAA case earlier. The employees still have full rights, the full requirement on Section 189. Obviously, as Marie said, the Section 189 of the Labour Relations Act could be fast-tracked. But now we've got this really unusual piece of court ruling that states that the practitioner is not allowed to, or it's unfair to go through a redundancy process whilst the business plan has yet to be published. Maurice, hopefully that captures it.
It certainly does. Thanks, Peter. So I think that's a wrap for today. There's further information on the COBRA website. That's www.cobra.org.za. If you have any specific queries, please email info@cobra.org.za. And importantly, bear in mind and remember that COBRA is pro bono if you qualify in terms of the means test, which is a very simple means test, and that is if professional fees come between a successful business rescue and a liquidation, we do not charge, or we reduce the fees to the point where it becomes affordable. To date, just to give you an idea of the level of pro bono assistance, I have worked full-time on assisting businesses over the last, since the lockdown, so call it 2 months, and not one fee has been charged. And that includes daily Zoom sessions with companies, meeting with their teams, dealing with specific questions, dealing with employees. In fact, I've met with employees explaining their rights to them. Our approach is, if you protect employees, you're in fact protecting the company itself. The more you preserve their rights, the more you're looking after the company because you're complying with substantive law. So you've got the benefit of that. I've been saying every day, think about it. Why would you not enter the COBRA ecosystem so that we can try and help you ease the pressure from creditors, but also specific advice, such as what we've just heard around PCF. That's critical. It's one piece of advice that could have massive financial implications on shareholders or directors. So that's the kind of advice you can expect to receive through COBRA. So thank you to the panelists. Thank you to the attendees. We have further webinars coming up. Tomorrow is quite an exciting day. Tomorrow we have a webinar dealing with tax. That's at 10 o'clock tomorrow morning. And then every week on a Friday, we have a weekly economic wrap-up, which have actually proven to be the most exciting and the most well-attended webinars of COBRA. And the wrap-up is various industry experts, but in particular, the head chief economist at IQ Business, Sifiso. Now, Sifiso is referred to as a secret weapon. I mean, I've known him only for about 6 weeks, and he is absolutely brilliant. So you've got to hear this guy because you'll binge watch him every single Friday. I can assure you of that, because he actually gives insights that I look forward to more than insights that one finds on CNN Business, etc. So please make a point of joining that webinar tomorrow. Thanks, guys. Until tomorrow. See you all then. Ciao.